We are going to court. There is a pretrial motions in the Karen Reed case today. We have seen on the docket motions for a continuance that's stipulated. It doesn't mean it will be granted. It should be, but it doesn't mean that it will be granted. So there are stipulated motion to continue. Then there are a bunch of discovery motions from both sides, the prosecution and the defense. This is the first time we're going to see the new special prosecutor in court. They are likely going to be not in the court we saw trial in. That wasn't Judge Cannone's regular court. We're going to be back in regular court. So we are not going to be in the Supreme Judicial Court today. They have not ruled yet. We're not going to be in the court where the trial was because, well, they're not in trial anymore. We're going to be back in the home court for Judge Cannone, and we're going to sit and watch the proceedings as they unfold.
All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, and they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, are in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right.
So today we were back in court in Massachusetts, back with Judge C, or Judge Cannone, who's presiding over the Karen Read case. She is now specially assigned to that case. We saw that filing on the docket because it seems that the judges in Massachusetts rotate, which kind of boggles my mind, but rotate between sitting in criminal assignments and sitting in civil assignments. So a case needs to be specially assigned to that judge. So it follows them no matter what type of assignment they are sitting in, which would be very hard, I think, to shift your brain between civil procedure and criminal procedure. I think it would be incredibly difficult, but she is specially assigned to this case. The defense way down the road made motions to remove the judge. That is incredibly unlikely to happen. We're not going to see, I mean, maybe we'll see another change of venue motion. It's unlikely we'll see that granted. It is getting too close to the wire. The judge, as she does, took all of the motions under submission, which means there will be written orders on all of the motions that were heard today, including the motion to continue the trial. Currently, the trial is set for January 27th, 2025. The defense and prosecution have asked together that the trial be moved out till April. The new prosecutor was in court today, so it's the first time we've seen Special Prosecutor Brennan in court arguing for the extensive motions that they covered today. They did not argue over the Commonwealth's motion that I talk about in today's podcast to try to get notes from one of the journalists who interviewed Karen Read. I expect that we will see more motions to get to the raw materials from Karen Read's interviews, because this prosecution team wants to use what she said in interviews against her in court if they can. Remember, what Karen Read says to an interviewer is not hearsay because it's being offered by the Commonwealth. So when I said, ooh, these make me nervous, these interviews make me nervous, they do. And the prosecution wants to get to all that information. I break all that down in today's episode of The Emily Show. But that was not discussed today or taken under advisement. The motion to continue was the Commonwealth's notice with regard to a new expert and retesting of the Lexus electronics systems, infotainment, telematics things, all of the technical parts of the vehicle. They are going to try to reassemble and retest. We heard argument over what was going on with the system and why they think they can retest, and how when Trooper Paul extracted it the first time, he didn't really know how to read it, and that reading came out wrong. They also talked about how they're going to quality control that to make sure nothing's changed in the data that's being downloaded, and giving the defense a heads up so their expert can observe that process and then have access to both the raw data and the conclusion. They also discussed whether there will be ongoing discovery motions, the Rule 17 motions. Those have been put out till another date at the end of November. And then they're putting out the Dauber motions, or motions over the experts, until the beginning of December. So we will see continuing motions leading up to this. I imagine, based on the questions, the judge will grant the continuance. I would be surprised if she didn't. I think the prosecution went a long way to try to speak to the judge directly, saying, we are working on cutting down the witness list significantly. We are working on making this a smoother trial, a cleaner presentation of evidence. We are working on really making sure that we can do this better, faster, but also said, of course, Your Honor, I will be ready if the court wants me to be ready in January. But I think a fair trial requires additional time for everyone to have this information and the new experts that the Commonwealth is bringing in and that the defense may need to bring in. So telling the judge it's going to be smoother and faster and less witnesses, I think, speaks directly to the judge's best interest as well in operating a smooth courtroom and having jurors there for a shorter amount of time. For the defense, they're not asking that that continuance be denied. The defense is on board with it, saying, yes, we want this information too. We want the digital information from Karen Read's car. It might very well benefit them. We've seen defense make statements to the media that they do not believe the state's case. They do not believe Karen Read did this. The defense has the best position to know what should be on Karen Read's car based on their conversations with Karen Read. So I'm not surprised that the defense is not arguing about the continuance. And I wonder if, when that information comes in, if the defense will be advocating again to narrow down the charges in this case. Is it unlikely? Yes. But is it something that they can ask for? also yes. And of course, we're going to see the judge's rulings probably next week, maybe a little longer, but the judge seems to be ready to move things along. That might shift if a continuance is granted, though she did set these motions in anticipation of a January trial. She didn't say, all right, well, let's set these motions in January. She said, we need to do these immediately. So she's denied continuances in the past. I've been surprised each time she denied a continuance. So it would surprise me if she denied the continuance. Then again, it would be keeping in line with her prior rulings in this case, being like, nah, I just want to be done. Let's get this done in January. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.